regarding the victim.
Thank you, Your Honor. We addressed this briefly earlier when I withdrew our request to admit the medical records. It's axiomatic and not disputed that a victim's good character and all the wonderful things about them is not relevant to a criminal trial. They don't really dispute that. What they do is they try to sort of come up with ways to backdoor that evidence by giving other reasons. Like they say, well, we need to explain why Mr. Souza hired Ms. Hutchins. And so Mr. Souza needs to explain all the background about Ms. Hutchins in order to explain his hiring process, which is, of course, completely irrelevant in the first place and an obvious backdoor and not particularly intellectually honest. Then they say, well, the reason we have to explain where she was born and how she grew up is because there's one moment in this case in thousands of pages in which one witness mentions that she speaks Russian to another witness. So in order to understand that, you have to understand where she grew up in Ukraine and all of that, and her childhood and all of that, to understand that. And of course, that's also intellectually dishonest. And all you have to say, if you care about making sure this court is, and this jury does not, decide this based on emotion and sympathy and the wrong reasons, is you have to say, did she speak Russian? Yes. Did you understand she understood Russian? Yes. You don't have to go into the 30 years of history here. So that's the way to deal with that. In terms of exhibits, it's also very, very simple. They talk about the lapels. I agree with them. The lapels at the scene are relevant. You don't show the positions of the bodies on the ground. It's not relevant. It's not in dispute. It's not a fact in dispute. It doesn't tend to prove anything. I agree with them. The autopsy is relevant. Not the photos. The photos don't help anything. The person who's doing the autopsy is more than sufficient. And let me say something else, and this is why I wanted to quickly withdraw the application for the medical records, which is we don't dispute anything about any of this. This is not an issue in this case. You will not hear us cross-examining or questioning the fact that she passed away or the cause. In the other trial in which you presided off, there was at least some testimony, some indicia that they intended to proceed that way, and maybe that had something to do with why so much of that evidence came in. That is not an issue in this trial. It's just not. And so every single time that evidence comes in, it's wholly irrelevant because I've just told the court we're not making an issue of it, and it's extremely prejudicial. It is the most extreme possible weighing of the scales that one could ever have, because it is completely irrelevant, because I'm saying, I agree, she passed away because of this. So, and their real reasons for doing this is obviously exposed.
Okay, so you're sort of combining everything. Why don't you go through each one that you identified?
Sure. The character of the deceased victims I just did. The moment of death and subsequent pain is obviously completely irrelevant. The emotion, they say in here.
Did you say completely relevant?
Irrelevant. They say that the reason that they're eliciting it is to bolster witness credibility. That is a per se improper reason. They say that they say evidence is relevant if it explains a witness's conduct and bolsters. They're using emotional sympathy, drama of something to bolster a witness's credibility. The fact that she suffered might be irrelevant or admissible in a wrongful death case. It's not an homicide case. It's nothing to do with it. Nothing. And to the idea that they're going to use it so that the witness is upset on a witness stand and saying, and this is how she fell, and her face was pale, and this, and now everybody's upset, and trust me, I saw what I saw about something relevant, is exactly what a court can't allow. It's exactly what a court can't allow. And they did this the entire trial with, and I mentioned this before with the, where is she now? Is she in the medical vac? They ask all of these, why is even one time, the tone of her skin as she falls, why is that possibly relevant to this trial? And they do it with every single witness. Every single witness they did it with. So then you get to the lapel cameras and the autopsy photos. And so I was trying to track this precisely. Again, we agree that the lapels of the scene are relevant, right? You just don't need to show a body on the ground. It's just not necessary. And the autopsy photos are particularly problematic. They don't show, how are they relevant? We could stay here for days and no one could explain to me how the autopsy photos are relevant. They're not. If the court wants to voir dire the medical examiner and say, is it possible for you to explain this without presenting these graphic, vivid depictions of a tragically killed person? They're going to say, of course I can't. Autopsy photos get ruled out all the time, especially in cases like this. This is not, a whodunit, where it's like, okay, let's look at this, but I'm saying I didn't do it. This is a tragic accident where two people who were known to each other and no animosity towards each other, this occurred. And so it doesn't have anything to do with the case or anything relevant. And I'm telling the court that we're not making an issue of this. So if the court knows that, unlike in the Hannah Gutierrez-Reed trial, that this is not in dispute, I really don't understand the basis to allow a single witness to do any of that, a single witness, let alone the cumulative every single witness, which is just being done to taint the jury and to try to get the jury to do something on sympathy. Thank you.
State.
The state has no intention of presenting evidence related to Ms. Hutchins' childhood. So we can eliminate that right off the bat.
What do you plan on?
Well, we believe that there is limited testimony from Mr. Souza that's appropriate because jurors don't know how the film industry works. He should be able to take the witness stand and say, as the director, I got to pick my director of photography. Here's what the director of photography does. These are the reasons I picked this person. We're not going to have him talk about, she's an honest person. She's an amazing mother. She's an amazing wife. None of that's coming in. But he gets to tell. We get to put the story in context for the jury, and I think that we can do that without doing all of these things that the defense is claiming are so highly prejudicial. I have no problem limiting that testimony with regard to Ms. Hutchins, but certainly the jury gets to hear what she did, how she was hired, how does this come together? How do all of these people come together on this movie set? That's absolutely relevant. Now, with regard to the lapel videos, the defense says, we think the lapel videos are relevant, but we just don't want the jury to see the human part of it. And that's kind of hard for the state because we kind of have to prove that a human being was killed. That's part of what we have to do here. So the other thing that you have to understand is that the defense probably is going to take a similar tactic in this regard that we saw in Gutierrez, and they're going to question all of the law enforcement officers about why didn't you do better? Why couldn't you have done this? And why couldn't you have done that? And the answer is, this was extremely chaotic. We've never shown up to a crime scene where there were 150 witnesses there. There were people mulling around everywhere. There were things that we had to do. Those lapel videos show how difficult and chaotic that scene was, and it goes directly to their defense. And listen, I mean, they act like these lapel videos are like a horror movie. You see Ms. Hutchins on the ground, you don't even see blood. You don't even see blood coming out of her. You see Mr. Souza's yelling because he got shot in the shoulder. That's not overly prejudicial. Absolutely not. There is tons of case law where, and the lapel video of them laying on the ground is very, very similar in terms of the analysis as the autopsy photos. Autopsy photos come in. They do. They come in every single case. I have never had a case where autopsy photos were excluded, and I even cite to a case in my response where the court actually says basically, we've never heard of a case where there was a reason to exclude these. They just come in. Now listen, I want this court to know that during Gutierrez and during this trial, there are autopsy photos in this case that are shocking to the conscience, that we could argue successfully are relevant. Because when you crack open somebody's body, you can see how the bullet traveled. And autopsy photos actually show that. We're not asking to get those in. We are doing exactly what we did in Gutierrez. We have just 2 to 4 very benign autopsy photos. We have been more than reasonable in terms of trying to turn down the volume on emotional response with regard to these autopsy photos. I was actually stunned to see this motion after we exercised so much restraint during the Gutierrez trial, and those are the same pictures. We haven't upped the ante here. We're not trying to show anything other than, look, this is where the bullet entered. This is where the bullet came out. Those are relevant. Those are relevant to Dr. Gerald's testimony. Those come in. They come in every single trial. There's just a reality associated with the fact that someone died. I am more than surprised to hear Mr. Spiro come up here and say, we are not disputing the cause of death. The whole reason that we have probably 4 or 5 witnesses on our witness list is because the defendant put Dr. Bianca Alvarez on their witness list. They called her, talked to her on the phone without inviting us. And the whole point to doing that has to do with this farce defense of she didn't die of a gunshot wound, she died because she wasn't intubated properly. So I want to say right now, because we're short on time in this trial, if the defense is not intending to make any arguments that she died because of a faulty intubation, let me know, because I can shave a lot of witnesses off my witness list that way.
Thank you.
Thank you.
State did not address even slightly in either their motion papers, in the Hannah Gutierrez-Reed trial, or in that response, anything about how ashen she is or how the moments happen after matter. They don't. They didn't address it in their papers. They didn't just address it now, right? So I just want to make sure that the court, as the court was well to point out to me, demark these issues. They have not addressed that. There is no dispute that that's not possibly relevant to talk about how the person was dying and what their skin looked like and their breathing. It's just not relevant. They then go into this, how Mr. Sousa selected her to understand the film industry working. I mean, Your Honor, it's like they don't ask a single other witness, right? Well, how did you get hired, and why did you get hired, right? I mean, so I'm sure that the court sees through this. If somebody were to say to me, this is the one question and answer, and there was an offer to proof, I'm sure we could work this out. But how can I possibly trust this process if we don't hear that exactly because of what I've seen? And then I'll just deal with the autopsy photos. Again, we're stipulating to identity and that she's deceased, and that we're not saying that some other causal factor killed her. So this makes the balancing test very, very easy. That doesn't happen in every homicide case, right? And also, I don't say these things in front of juries, but I actually prosecuted homicide cases. No, and often there is a discussion over, they don't always come in, and often there is this thing where sometimes prosecutors want to put them in to gin up the jury, and judges make calls all the time that it's just not necessary. We don't need to remember her that way. We don't need to do that in this case. I don't need to do that in this case. And this court can very well, like the court said to me when this hearing opened, take order of the court and has the discretion to say, no, pictures of this tragic dead body is not necessary here. I'm telling the court again, I'll say it now, I think a second time, which is we are not making an issue out of the cause of death, period. They want to take these people off the witness list, they can. But if that's what we're doing, and I've withdrawn our seeking the medical records, then I've left the court with a very simple, in my judgment, balancing test. And I'd ask the court to really think about when this verdict comes down, having faith that this was a fair trial and the verdict was based on the right reasons. You can't have, I mean, it's hours of testimony, hours in the Hannah Gutierrez-Reed trial about it, and it's different here because the gun was in his hand. The gun was in his hand. So to allow hours and hours of testimony, when we have, the state has 5 days to present this case, and we need the opportunity to rigorously cross-examine, it doesn't make any sense. I don't think it's fair, and I don't think the court should allow it. Thank you.
All right, the court makes the following ruling. All right, with respect to the character of deceased of the deceased, certainly if Mr. Baldwin was going to get up, you'd want to go, how did you come about getting this this job, so to speak? And I think it's just an introductory way to tell the story. Now, I do remember Mr. Souza going into, we met, I liked her, we had things in common, you know, et cetera, et cetera. I think all that needs to be said is that she was one of some choices. He felt that she was a good fit and that she was the director of photography. That's it. Okay. Now, with respect to the moment of death and subsequent pain, I think that does go to the death. That's one of the elements, and the death and the injury, well, the death, and I do think that that makes a fact more probative, and that is the death, and that I don't think that is its probative value substantially outweighed by unfair prejudice. Having said that, I'm trying to recall everything that occurred regarding that, and I do think that the video is appropriate. Now, I think there were some people that got up, and this may be what both of you have referred to, where they talked about being upset, they talked about how upsetting it was and things like that. We don't need that. We just need the lapels videos as to what happened with respect to her being shot and Mr. Souza being shot as well. So that's the lapel camera depicting the crime scene. Am I misunderstanding anything else on that?
From the defense's perspective, a lot of this also goes to 403 and cumulativeness, right? So
could you just answer my question? Okay?
Yeah, well, I think the answer
I don't want
is
you to
yes.
argue again. You already had your chance.
I think the answer is yes, Your Honor. I'm not. If I understood the court's ruling, I think the answer is that yes. If the lapel videos are the way that they're going to show where the bodies were, or the man.
When Lieutenant Benavides is in there and he says, "Everybody clear out." Is that the video?
And primarily also Officer LaFleur, who's the first officer on scene. That video
right,
also
where people are rendering aid.
Right.
Yeah. All right. So that comes in. Autopsy photos. Again, you can stipulate. That's fine, but they're allowed to tell their story, and they're allowed to demonstrate the death. I do remember there was an autopsy photo that was pretty much agreed it was prejudicial, or maybe it was somewhere else where her shirt, I think. Which part of the autopsy photos? I don't know. But the autopsy photos, in my mind, are the body.
So just to iron it out right now, we've got pretty much the same photos of the body that we showed during Gutierrez. Nothing overly dramatic. And there is a photo of the bloody clothing, and part of the reason that's relevant is because her cause of death was exsanguination, so she bled to death. So the photos of that amount of blood go directly to her cause of death.
I will allow that.
Looking at the kinds of violations like we've seen in this case, it has materially impacted the defendant's ability to be able to prepare for trial, to be able to interview the witnesses, to be able to seek out its own experts and do whatever it is that we need to do on the case. when there have been so many continual discovery violations. So the more narrowly tailored remedy that the court could fashion, even though it would not put us completely in the position that we would be otherwise, the closest that we could probably get is if the court were to look at these topics for which we still have these disclosure issues, for which they've now just disclosed these things from their expert witnesses, again, the week before trial when they've had some of these for over a year, and say, I see that there is prejudice, I see that there were violations, and there's prejudice to the defense. So we will not allow the state to benefit or to put on these topics of evidence because the defense is not in the position that they would have been had these documents, had this discovery been disclosed in the timely manner that they were supposed to be. And frankly, while we still want disclosure now, and we are asking that the court lift the redactions and ask for an in-camera review of the documents that we've provided as the exhibits that we still have that are redacted, that we don't have the ability to see the contents of, we would ask that the court lift those redactions so that we can see what's in there. But there is nothing that can cure the fact that these things have been disclosed so late in the day that there's not much we can do with them. So we are asking that those topics that I've outlined in Exhibits N, O, P, and L, that the state not be permitted to introduce evidence or testimony related to those topics, since we are at a disadvantage because of their withholding of this information. And we would also ask that, similar to the other motion that we had done where the court ordered that the jury would be informed of the violation with respect to the Hague report, for example, we're asking that the court allow us to submit a similar instruction with respect to their violations in this instance, so that the jury can know and actually draw their own inference that this information would have been helpful to the defense had they been able to see it.
So you're asking me for 4 solutions. One is to dismiss the case. The second is to eliminate subject matter. The third one is that, which is ongoing, is for them to keep going, keep looking. And then the last one is
The inference instruction.
well, what you're asking for is a continuance. So why don't you come out and say it? Because you don't want one.
We
How
don't,
are
that's
they
correct.
going to keep looking for things without a continuance?
What we're asking, Your Honor, for right now is those specific documents
No,
that I
you're
provided to
asking
the
for
court.
4 things, okay? And I'm asking you, how is that not going to help if I don't give you a continuance? You are essentially asking for a continuance because you're saying they have to keep looking. We have 8 days of trial and they have to keep doing this. What does that mean? How does that compute?
So, Your Honor, so what we're asking for is not actually a continuance, and we're not even asking for those extended things. What we're asking for is we've identified a discrete number of documents right now.
You've got to adjust your request then.
Okay, Your
What
Honor,
is
so
it?
let me try to do that then. So what we've handed to the court is a number of documents that still remain redacted. We cannot see the contents, is what we've provided to the court. We're asking that the court lift those redactions, or order that the state lift those redactions, so that we can see what those are, because those are clearly discoverable and yet we still don't have the contents. That's one request that we're making. The other request is related to exclusion of subject matter, and that's because we don't want a continuance. We don't want a
What is the
continuance.
subject matter you want?
The subject matter, Your Honor, that we're asking the court to not permit are those subjects that are included in those exhibits that I just detailed for the court. And so that would be, yes. And so, Your Honor, what we would like to do at this point, because we understand, again, this is a difficult position. It's difficult for us. It's not where we want to be. It's difficult for the court, because here we are at the eve of trial. We don't want a continuance. The court has already ordered us to meet and confer. My understanding, actually, from Mr. Spiro is that the state had indicated to him, I guess a moment ago before we argued this, that they have some additional disclosures that they would be making. I don't know if that includes potentially what we're asking for with respect to lifting of those redactions. I'm not sure what that involves. I wasn't part of the conversation. So we may be able to get something out of a meet and confer where some of the remedies that we're seeking may already be addressed. So if the court would allow us to do that meet and confer, then perhaps we can bring this again before the court once we know what situation we are in currently.
Thank you. State.
Thank you, Your Honor. Your Honor, first, as the court knows, I'm somewhat newer to this particular case, but the state has complied. I did receive the request, and Ms. Morrissey didn't have the unredacted IPRA. I requested the unredacted IPRA. We went through all of those documents and made those disclosures. They have the information, and the information that they want is information they're not entitled to. So they received information that was subject to disclosure under 5501A6, 5501G, and these are emails is what we're talking about. They're emails with witnesses. And just to give you an example, Judge, I brought the unredacted, and I'd like to give it to the court for an in-camera inspection, and you will see they're not entitled to it. They're not entitled to that information because it's not statements from witness. For example, the email where Ms. Paget says, we have to disclose this. Well, it's actually the contents of what the person, it's a paralegal emailing the DA's office. That's not a witness statement, and it's just basically saying, hey, we need to get these things, and they need to be disclosed. So if the court would like to take a look at it, Your Honor, for an in-camera inspection, if I may. Well, no, no, Your Honor, because it's for an in-camera inspection, just for the court. So it's the last page, Your Honor, where it begins after Ms. Paget signs, "Thanks, Jennifer." It's a very second to the last page. You'll see it's an email from a paralegal at a law firm. They're not entitled to that. What the defense is complaining about is they want communications between the attorneys. They want communications between paralegals and the attorneys. They're not entitled to that. They're not entitled to our strategy. They're entitled to witness
How
statements.
would they know that? Why can't you tell them they're not entitled to this?
I
Because
did, Your Honor. I went through and I disclosed numerous disclosures. And I specifically in those emails stated, and they attach them as exhibits, these are being disclosed because they were found to contain information that is subject to disclosure. So if it's still redacted, it's not subject to disclosure. And so the other documents, Your Honor, I'm happy to submit those to the court for an in-camera inspection.
I'm not going to do an in-camera inspection. I'm ready for trial.
Yes, Your
Okay.
Honor. And I understand. And what I'm telling you as an officer of the court, as a representative of the state, I went through these.
Why so late?
Your Honor, I was requested on June 27th to do, because
Well, I'm asking the state in general.
Ms. Morrissey didn't have a copy of the unredacted IPRA, Your Honor. So a lot of these happened
Why
before.
did you give them IPRA?
Well, what happened was the defense requested an IPRA in October of 2023. Mr.
Well, you
Baldwin.
knew what was going to happen with that. Balloon.
Yes, and Mr. Baldwin wasn't charged at the time. So that when they received the production from the state, he was then, at that point, charged. I believe it was in May. They asked Ms. Morrissey, would you please unredact? Well, it was thousands, as you noted. Ms. Morrissey asked, tell me which ones you want unredacted, and I'll take a look at them. She received no
This is
response.
all about the IPRA. Is this correct?
Yes,
This
it
is all
is.
about the IPRA.
It is.
This isn't about any other discovery that was disclosed except what was disclosed in the IPRA.
Yes, and they're witness statements. That's what it is. So a proper remedy, Your Honor, under Harper is a continuance. It's a continuance. They have the information now. As far as the third Hague report, the court addressed that in the Brady motion. As far as this is concerned, they're statements. And the state has gone through, disclosed to what.
Have you already given them the statements?
That's what was unredacted. That's what we went through and unredacted.
What other redactions does she want?
She wants essentially what I just handed to the court.
in-camera, the ones that you said you can't do.
Exactly.
Well, you'd have to make if they responded that this is privileged information, I can't do it for you. You're going to have to make arguments on why the redacted portions of the IPRA request that she has kept redacted are fair game. And this is all about IPRA, is what I'm understanding.
There's statements that were obtained, yes, Your Honor, emails. There are thousands of pages of emails. And so, Your Honor, the proper remedy, they haven't shown how they're prejudiced.
So obviously you can tell the court is not happy with this. We are in recess, go confer, and I'll see what's going to happen. I will give you an hour.
Thank you.
We're in recess.
When someone plays make-believe with a real gun in a real-life workplace, and while playing make-believe with that gun violates the cardinal rules of firearm safety, people's lives are endangered, and someone could be killed. Ladies and gentlemen, that's what this case is about. It's simple, it's straightforward. The evidence will show that someone who played make-believe with a real gun and violated the cardinal rules of firearm safety is the defendant, Alexander Baldwin. You will hear over the course of the next few days that in the fall of 2021, a movie called Rust began filming at the Bonanza Creek Ranch just south of Santa Fe in Santa Fe County. You will learn that this movie was a Western with a lot of gun action. And while it was a movie set, it was a real-life workplace for many people. But you will hear this workplace was on a tight budget. And you will learn that some of the people who were hired to work at this workplace were very inexperienced. And one of those was the armorer, a very young woman named Hannah Gutierrez-Reed. You will hear testimony from crew members who worked on the set, who will tell you that to them, Ms. Gutierrez's inexperience was obvious. You will also learn that this workplace has some talented people. And one of those was the director of photography, a vibrant 42-year-old rising star named Halyna Hutchins. You will also learn that the director of this film was Joel Souza, another talented individual who cares deeply for his projects. The evidence will show, ladies and gentlemen, that like in many workplaces, there are people who act in a reckless manner and place other individuals in danger and act without due regard for the safety of others. That, you will hear, was the defendant, Alexander Baldwin, the lead actor on this film. You will learn that this movie began filming on or about October 6, 2021. But the defendant did not arrive on set to begin working until about October 13. And you will learn that prior to arriving on the set to work, he requested to be assigned the biggest gun available. So he was assigned this revolver, a replica of an 1873 single-action revolver manufactured by Pieta Firearms in Italy. You will hear from Alessandro Pieta, who will tell you he manufactured this gun. And he will tell you he manufactured it in 2015. And he will explain the quality control measures that Pieta Firearms follows in order to ensure that firearms that are manufactured by Pieta Firearms don't have any problems or issues. Mr. Pieta will tell you that this firearm he himself manufactured, and that when Pieta sent it to EMF, which is the company that distributes firearms for Pieta Firearms in the United States, this gun was in perfect working condition. You will hear from Justin Neal, who is a representative of EMF, a company out of California that has historically been known to provide firearms to the movie industry. Mr. Neal will tell you that when EMF received this firearm in 2017, it was in perfect working order. And in fact, when EMF had this firearm, it was subjected to numerous quality control inspections because it was used as a show gun at gun shows. The evidence will show that in September of 2021, an individual by the name of Seth Kenny was contacted by the folks with Rust Production. They asked Mr. Kenny if he would be able to provide some firearms for the filming, for use during the filming of Rust. You will learn that Mr. Kenny owns PDQ Firearm and Prop. It's a duly licensed firearms dealership. Mr. Kenny then contacted EMF and ordered several single-action replica revolvers. And in September, or on September 29, 2021, Mr. Kenny purchased this gun. And you will hear that Mr. Kenny received it from EMF, and it was in perfect working order. The only thing that Mr. Kenny did to this gun was to insert the firing pin, because since it was a show gun, it didn't have a firing pin. But you'll learn that that's a very easy step. All he had to do was just insert the pin, and that's it. And then Mr. Kenny had the firearms, this one and some other firearms, transferred to the set of Rust at the Bonanza Creek Ranch. And on October 13th, 2021, the defendant was supposed to have a training session with this gun and this young armorer. But you will see that during this training session, the defendant had somebody or a couple of people filming him while he's running around shooting this gun. You will learn, ladies and gentlemen, or you'll hear during this trial the use of the words prop gun. And you'll learn a prop gun is this real gun. It's not a toy. It's not made of rubber. It's a real gun. You will also see evidence, ladies and gentlemen, that during the days before that fateful October 21st day, the defendant handled this firearm multiple occasions. You will see video footage of the defendant firing this firearm, working perfectly fine. But you'll see evidence, ladies and gentlemen, that each time the defendant handled this firearm, he did not do a safety check with that inexperienced armorer. And you'll hear that the reason he didn't do a safety check is because he didn't want to offend her. The evidence you will see will paint a real-life picture of a real-life workplace where this defendant mishandled this gun. You will see him using this gun as a pointer to point at people, to point at things. You will see him cock the hammer when he's not supposed to cock the hammer. You will see him put his finger on the trigger when his finger's not supposed to be on the trigger. You will hear about numerous breaches of firearm safety with this defendant and this use of this firearm. And the evidence will show that on the morning of October 21st, 2021, the camera crew walked off set. And you will learn that one of the reasons that camera crew walked out is because they were concerned over safety breaches with the use of firearms. The evidence will show that the morning of October 21st started out a couple of hours behind. They filmed some scenes at this church on the Bonanza Creek Ranch. And you will see that one of those scenes required the defendant to pull out his gun. This was in the morning. Pull out his gun, and you'll hear the director tell him, pull it out and hold it. And the first time, you'll see evidence the defendant does what the director tells him. But you will hear the director tell you that many times the defendant would do his own thing. So then the director in the morning asked him, okay, do it again, just like you did now. The defendant pulls out the gun, but this time he cocks the hammer. The evidence will show they then broke for lunch. And around 1:30 or so, they came back to this church to do what's called a blocking. The evidence will show that Ms. Hutchins wanted to do a blocking for an insert. And you will learn what a blocking is, just working out the details of the moves of the actor. It wasn't even a rehearsal. You will hear from one of the witnesses who walked into the church and saw the defendant kind of playing with his gun. And then you will see evidence or hear evidence that Ms. Hutchins and Mr. Souza were talking to the defendant about doing this insert. And the insert was just supposed to be from here to here, and it was supposed to be of the defendant just slowly taking his gun out of his holster, and just holding it at an angle. The evidence will show that someone asked the armorer to bring the defendant's gun to him, and she did. She brought it into the church, showed it to David Halls, who you will learn was the first assistant director. The gun was empty. Ms. Gutierrez then handed the gun to the defendant. But then you will hear that Ms. Gutierrez was given the gun back, and she took it and loaded it with dummy rounds. And what you will learn is that dummy rounds are inert rounds. They look like real rounds, but they are very easy to tell that they are not because they'll rattle. Ms. Gutierrez then went back to the church, showed the revolver to the first assistant director very fast. They only checked about 3 rounds, very quick. And they missed 1 round. You will learn that one of the rounds in that revolver was a real round. And the evidence will show that Ms. Gutierrez then handed the gun to the defendant. And what you will learn is that once again, the defendant failed to do a gun check or a safety check with this armorer. So he takes the firearm, puts it in his holster. Then Ms. Hutchins and Mr. Souza were doing this blocking. And the evidence will show, ladies and gentlemen, that the defendant, again, did his own thing. You will hear from an individual by the name of Kent Jorgensen. Mr. Jorgensen will tell you that he's been involved in drafting and revising movie set safety rules. You will learn that these movie set safety rules require actors, like the defendant, to treat every firearm as though it's loaded, to never point a firearm at another person, and to never put your finger on the trigger unless you're prepared to shoot or to destroy whatever's in front of you. The evidence will show that on October 21st, 2021, after that lunch break, the defendant once again violated those set safety rules. And during this blocking, the director had instructed him to just slowly take out that gun and just hold it at an angle. But you will see that the defendant takes it out quickly the first time, points it. And you will hear witness testimony who will tell you the first time he does it, his finger is on or around the trigger. He does it again, takes it out very fast, points it. And once again, you will hear testimony that his finger was on or around the trigger. And the evidence will show that that third and fatal time, he takes it out once again, fast, hammer's cocked, he cocks the hammer, points it straight at Ms. Hutchins and fires that gun, sending that live bullet right into Ms. Hutchins' body. You will learn that this bullet was a .45 caliber round that entered Ms. Hutchins' body right underneath her right underarm. It perforated her right lung. It traveled through her spine, lacerating her spinal cord, and then it exited on the left side of her back. That bullet then went into Joel Souza's right shoulder, and it came to rest in his back, from where doctors removed it once he was transported to St. Vincent's Hospital here in Santa Fe. You will learn, ladies and gentlemen, that Ms. Hutchins did not have the same fate. You will see the aftermath of the shooting, and you will see medics frantically working to save Ms. Hutchins, to stabilize her, to transport her, to airlift her to UNM Hospital. But the damage from that bullet was too much. Ms. Hutchins succumbed to her injuries and bled to death. The evidence will show that meanwhile, after the shooting, the defendant began to claim he didn't pull the trigger. The evidence will show, ladies and gentlemen, that's not possible. You will hear from Mr. Pieta himself, who will tell you that gun will not discharge without a pull of the trigger. You will hear from firearms experts who will tell you that gun will not discharge without a pull of that trigger. The evidence will show that law enforcement officials arrived at the scene on October 21st after the shooting and immediately took this gun into their custody. Then later, they asked the FBI for assistance in processing this gun for forensics and examination. You will learn that the gun and some ammunition that was taken from the set and from PDQ arms were sent to the FBI for analysis. You will learn that the gun first went to the DNA section of the lab, where a DNA analyst found the defendant's DNA on this gun, and then the gun was transferred to the firearms and tool mark section of the lab, where a firearms examiner examined this gun very carefully and closely. Bryce Ziegler, who is the firearms examiner for the FBI, will tell you that when he received this firearm, he first examined it. He didn't see any defects, didn't see any modifications. He tried and he checked the hammer in the 3 different positions, cocking positions. He checked the quarter cock position, fine. Checked the half cock position, fine. Checked the full cock position, fine. And when he held it in the full cock position, you will hear that hammer held until he pulled the trigger. You will also hear that Mr. Ziegler test fired this gun 12 different times. And each time, that gun fired as it was designed. Each time, when he pulled that trigger, it fired. And he will tell you that not once did this gun malfunction or discharge on its own. Now, the evidence will show that because the defendant had been claiming that he didn't pull the trigger, Mr. Ziegler suggested one last test to the Sheriff's Department. Mr. Ziegler told the Sheriff's Department that he could do what's called an accidental discharge test. He obtained authorization to do this test, and you will hear that he left that test for last because that test could potentially damage the gun. Mr. Ziegler went forward after he received this authorization and conducted the accidental discharge test. And you will hear, ladies and gentlemen, that during that test, a couple of the internal components of this firearm damaged. You will hear that the trigger sear and the full cock hammer notch were damaged during the accidental discharge testing. The evidence will show, however, that before this accidental discharge testing by the FBI, this gun functioned and worked perfectly fine. You'll see the video footage of the multiple occasions during which the defendant used this firearm on the set, and each time he fired it, it was working just fine. And in fact, you'll hear evidence that the defendant himself admitted in December of 2021 that this gun didn't have any mechanical problems. You will hear from the two of the country's leading experts on firearms forensics, Michael Hague and Lucian Hague. And they will tell you that they examined the revolver and the damaged pieces extensively. They will tell you that the damage to the full cock trigger notch is consistent with the accidental discharge testing that was conducted by the FBI. Lucian Hague will tell you that in August of 2023, he examined the trigger sear, the other piece, and that when he looked at it initially with the naked eye, there was nothing wrong with it. He couldn't see anything. But then he put it under the microscope, and he noticed some kind of rough microscopic diagonal lines on the surface of the trigger sear. And since at the time he did not know how Mr. Ziegler had conducted the accidental discharge test, he opined that these very small microscopic lines were likely not caused by the FBI accidental discharge testing, but he could not exclude that as the source of those lines. Then a few weeks ago, Mr. Hague will tell you that he spoke with Mr. Ziegler, and he learned how Mr. Ziegler had conducted the accidental discharge test. Mr. Ziegler explained that he affixed that firearm onto a fixed platform and then struck the firearm on 6 different planes with a rubber mallet. And Mr. Ziegler explained to Mr. Hague that he had not affixed the mallet to another fixed device. Instead, he did it freehand. Mr. Hague will tell you, with his 50-plus years of experience as a firearms forensics expert, he opined or concluded that those very tiny microscopic diagonal lines on the surface of the trigger sear were likely caused by the FBI's accidental discharge test. The evidence will show, ladies and gentlemen, that regardless of how those tiny microscopic lines got on that trigger sear, these firearms experts will tell you that those would not affect the functionality of this firearm. At the end of this case, ladies and gentlemen, you are going to conclude and be convinced beyond a reasonable doubt that on October 21st, 2021, that gun the defendant had asked to be assigned worked perfectly fine as it was designed, and that the fatal and one of the main problems that afternoon of October 21st was that the defendant didn't do a gun safety check with that inexperienced armorer. He pointed the gun at another human being, cocked the hammer, and pulled that trigger in reckless disregard for Ms. Hutchins' safety. And you will be convinced that the only true and just verdict in this case, so that true justice can be served, is a verdict of guilty to involuntary manslaughter. Thank you.
Sorry, Mr. Spire.
Oh, sorry.
Get that out of your way.
It's always fine when the court interrupts me. Then may I proceed?
Yes.
Yeah. Thank you. When you got to the scene, Mr. Baldwin walked up to you and said, I was holding a gun. He blurted it out, right?
Yes.
And in fact, he was very shocked, if you could picture Alec Baldwin in a pale state, very unsure of himself. you could say an actor out of character. Fair?
Sure.
Object to the former question. It is Mr. Spiro testifying in the question. Okay. May we approach?
Mr. Baldwin, he looked very shocked. If you could picture Mr. Baldwin in a pale state, like unsure of himself, you could say an actor out of character. Is that a fair description?
Sure.
And he said to you, I'm here, whatever you want to do, right?
Yes.
He said to you at one point, where should I go? Right?
Yes.
And he also pointed out to you who the director was on scene who was hit in the shoulder, right?
I believe so. Yes. I inquired about him.
And he also asked you how she was doing, right? Meaning Miss Hutchins, right?
Yes.
I don't remember you being asked about that on direct, were you?
And you mean asked by the state?
Yeah.
Objection relevance?
Overruled.
So I want to take a step back. The dispatch that came over to your radio, sir, before you got to the scene was a dispatch for an accidental shooting by a prop gun, correct?
I believe that's what was told to me, yes.
Okay. And you've testified to that previously, right?
Yes.
Okay. And the dispatch report, you know that you received that wording, accidental discharge, several times, right?
I believe so.
Okay. So I want to ask you, how come when you described it today in court, how come you didn't include the word accident when you testified before this jury?
I'm not one to say if it was an accident or not. Just there to initially respond to it, and then the detectives determine whether or not it was an accident.
Well, sure, but every other time you've been asked about this, you've said it was an accident. And now today at the trial of Alec Baldwin, when you're talking to this jury, you left that word out. Isn't that true?
Not intentionally, no.
Did you meet with the prosecutors before you testified here today?
Just briefly in the room outside for them to tell me who was in order of what witness.
You've discussed your testimony previously with Ms. Morrissey, correct? Before today?
Just in a pretrial interview, yes.
We've talked about your lapel that was on. It's true, right, that the lapel is actually mandatory,
Yes.
right? And so they came to the officers, passed a law, and told you had to wear your lapel, right?
Yes.
And the way it works is it secures all of these statements, and when you're done wearing it for the day, you go back to the station, you log it in, and then it exists, right?
Essentially, yeah, but it's more complex than that. It uploads on itself.
Oh, it self-uploads so that it maintains itself?
Yes.
Okay. And you then talked a little bit about the securing of the scene, and you talked about crime scene tape going up, right?
Yes.
But as you just told this jury, at the time, you don't know whether this is an accident or not, right?
Yes.
It's not like a crime scene tape is some evidence of a crime, right?
Whether it was an accident or a crime scene is still essential.
And you've been very candid that you made some mistakes at the scene, right?
Yes.
And that you've learned since then about some of these mistakes, right?
Yes.
You've said hindsight's 20/20, right?
Yes.
And you can Monday morning quarterback decisions, but you made them in the field, right?
Yes.
Okay. And you've said that based on your training and experience, you know that if witnesses are left to speak to each other, they can taint each other's memories, right?
Yes.
And sometimes that's incidental and accidental, right?
Yes.
And sometimes it's purposeful, right?
Depends on who's there, yes.
Well, if you were with somebody and somebody was talking to you about the 911 call, right? and they kept saying to you over and over, it wasn't an accident, it wasn't an accident, and then you testify and you leave out the word accident, that could be an example of taint, couldn't it?
Sure.
And also, non-witnesses can taint people's memories too. You agree with me?
I guess.
Well, you know, at one point in your testimony previously, you had said that there was a lawyer on the scene that was talking to some of the people that were on the scene.
I believe so, yeah.
Okay. And if that lawyer told somebody on the scene, I think your understanding is that could have tainted their view or their memory, right?
Essentially, yes.
Mr. Baldwin never asked to speak to that lawyer, did he?
Not to my recollection.
And, you know, then you went on and you said, you know, that you had told Mr. Baldwin not to speak to the other witnesses. Do you remember that testimony?
Yes.
And I think you were asked approximately 5 times why Mr. Baldwin was disobeying your orders. Do you remember that testimony?
Yes.
Okay. But in the lapel video that we just saw, you're not going up to Mr. Baldwin or these witnesses going, get out of here. Get out of here. I'm an officer. You got to separate. You don't do that, right?
Nope.
And also in that video, you can see a lot of these people are coming over to Mr. Baldwin, right?
Yes.
One of them comes over and shakes his hand, right?
Yes.
Have you ever seen that in all of your experience? Somebody commit a homicide, and everybody and all the witnesses are on the scene, circling around the person, shaking his hand and talking to him about what happened. Have you ever seen that in your entire career?
No.
And then you went on to say, well, you didn't put him in the cruiser. You didn't put him in the cruiser because your cruiser was being used. Was I guess the reason that you gave? Was that? Did I understand that right?
My patrol unit was being actively used as a post on the other side of the field for a crime scene.
When you say a post, you mean like it goes somewhere else and you put the tape around it? Is that?
The side mirror was wrapped around with crime scene tape.
Uh-huh. You mean there were also another dozen officers on the scene that day that had police cars if they wanted to put Mr. Baldwin in it at any point, right?
Yep.
Okay. And in fact, Mr. Baldwin later on drives himself to the precinct and goes and speaks to the police, right?
I'm not too sure how he got there, but he did get there.
Well, he wasn't under arrest, right?
Not to my knowledge, no.
And so you use this word detained. When Miss Morrissey asked you, well, were you detaining Mr. Baldwin? Do you remember that question?
Yes.
Isn't it true that even today, years later, no police officer has ever arrested Mr. Baldwin or detained him in a police car? True?
I don't know.
The police department, the Santa Fe Police Department, has never arrested Mr. Baldwin.
Not the
Back
Santa
to
Fe
the
Police
form of
Department.
question, asked and answered.
And one of the things that you do as an officer on the scene is you observe demeanor, right?
Yes.
And you spent 10 hours on the scene, I think I heard you say, right?
Yes.
You got to see the people of Rust that day live, right?
Yes.
And the truth of the matter is that you took it as a way how everybody was acting and that the individual who claimed to have been holding the firearm was still there, that there was no, the way he was, his demeanor was that there wasn't any intention behind the act, as you could say. Isn't that true?
I wouldn't say there was no intention. I don't know the individual's intentions, but his demeanor was sad, upset.
Okay, well, it's not just his demeanor being sad and upset, right? Okay, we'll move that to the side. And I understand you're not a mind reader, right? Correct?
Yes.
Okay. All you can do is look at the people and look at how they're interacting and make your own judgments, right?
Yes.
Okay, and you do that as a police officer to try to figure out how to interact with a scene. True?
Yes.
Okay, and isn't it true that the way you took it, how everybody was acting and that the individual who claimed to have been holding the firearm was still there, that there was no, the way he was, his demeanor was that there wasn't any intention behind the act, as you could say. Isn't that true?
Again, the wording you're using, I wouldn't say I
Okay.
had any clue of whose intention was what, but he was sad and upset.
Okay, well, let's play. I'm going to play his statement to that effect. Can we cue that up, please, if that's okay with the court? He's saying he didn't say that he did. I'm going to impeach him.
I don't think he said he didn't.
Well, you want me to clarify that? Yeah. Okay. Are you claiming that you didn't say that?
Rephrase what you said.
Sure. Dispatch said it was an accidental shooting by a prop gun. So I didn't know if there was any. I took it as the way how everybody was acting and that the individual who claimed to have been holding the firearm was still there, that there was no, the way he was, his demeanor was that there wasn't any intention behind the act, as you could say, you know.
Again, I wouldn't say I knew what his intention was.
I understand that. What I'm asking you now, okay, is did you in fact say those words that I just asked you?
At what time? The Gutierrez or PTI?
Yes.
I may have.
Okay. You don't deny saying that?
Your Honor, let's approach
No.
if we can.
Sure. One more time, I'm just going to ask you, did you say that statement that I read?
If you're reading the statement and it says my name next to it, then I more likely said it. I just don't recall when.
And one of the other things that happened that day that I don't think we've talked about is you spoke to a witness who told you that a woman named Sarah was crying and shaking and going through the bullets and saying, I don't know how it got in there.
Objection, hearsay.
I'm asking the witness if he had that information.
But he's making the statement, the hearsay statement is coming in.
Do you know whether anybody at the scene was, before you got there, shaking and going through the bullets and saying, I don't know how it got in there?
I don't know.
Okay. If we could refresh the witness with his lapel, and I would ask that can I put it up on just his screen?
Okay.
I don't think you can do that.
I would object because that's not proper refreshment. We don't refresh in front of the jurors. That's my objection.
What do you mean?
Well, if we're refreshing,
You know what, we're gonna take a lunch break real quick, and we're gonna be back at 1 o'clock, okay? Please don't talk among yourselves.
Will rise for the jury.
All right, you're excused. You can move over. And this thing is a battery, and counsel approach.
For you and Detective, you said to Detective Hancock, you know, this is taking a long time. We really need a spa day.
objection relevance?
What's relevant?
The-
What's
the-
relevant?
the relevance
Does it
is
have
that
any
it's-
more tendency to?
Sure.
I'm going to sustain the objection.
Okay. Did you and Detective Hancock start joking around that it was going to take too long to search every box?
I don't recall that.
Do you deny it?
No.
And there are times in this search where you pick up a box and you just shake the whole box, right?
I don't recall that.
Can we play that video?
I'm confused. Is he refreshing or is he impeaching?
It doesn't matter. It's just a video. It's not a statement.
No, it does matter because she said she doesn't recall.
Okay, well, let me ask you this. Do you deny, in parts of your search, just picking up a box and shaking it to see if it shook or not? Do you deny that?
No.
And so, but if you shook an entire box to see if it had a rattle in it, you wouldn't be able to be sure whether or not every single live round, it was all live rounds or a commingled group, correct?
Correct.
In fact, that's the entire basis of the case of what you believe the armorer to have done. Commingled, live, and dummies, right?
Yes.
And yet at the search being conducted to find the source of the lethal round, law enforcement is doing the very same thing that you're complaining about the armorer doing on the set, right?
Yes.
And when you left that search, you are not, as you sit here, sure you got every live round, are you?
No.
And actually, if you look at the boxes inside of that location, you didn't even search half of them. Did you?
I don't recall.
So then why on direct examination, if you do not recall, did the prosecutor ask you, and you tell this jury, that you were confirming that you searched and found every single live round? Why did you testify to that?
I found what I believe to be all the live rounds at the warehouse.
But that's not what you said. What you said was that you found every live round, right?
I don't recall the exact words that I stated.
Well, you certainly said that you searched every single box just 10 minutes ago in front of this jury, right?
I believe that a reasonable search was conducted of the warehouse.
An investigator, I understand you were prepped before you testified today, correct?
I spoke with the prosecution before I testified yesterday.
Okay. And the jury heard something about pre-trial interviews, where you're interviewed and the defense can be there to watch you be interviewed, right?
Yes.
But every time you talk to the prosecutors, defense is not there, correct?
Correct.
In fact, the vast majority of times you speak to the prosecutors, the defense is not there, correct?
Correct.
In fact, you and I had never met before today, or yesterday, I guess, correct?
Yes.
So, you just said, when you originally said that you searched every box, okay, that itself is not accurate, correct?
Correct.
Okay. So now what you're saying is that you did a reasonable search, correct?
Yes.
Okay. And the other thing that the search warrant asked you to take was the cameras and the camera equipment, the surveillance footage from PDQ, right?
I don't recall that.
Okay, I'm going to pass up the warrant to refresh your recollection. Well, do you recall that there was camera equipment there?
There was lots of camera equipment inside of the warehouse.
In fact, you remember Seth Kenny showed you the camera equipment, right?
I don't recall exactly.
Okay, I'm just going to mark this as defense Z and just approach just quickly.
If you all want, but I'm going to require that the state, in fact, I'm going to order that the state by 11:30 this morning produce the supplemental report, the file itself, and anything in it, and also the rounds.
May I
that-
respond real
I'm not
quick?
finished.
Okay.
And the rounds that Ms. Popple took from Mr. Teskey.
I want the court to understand that last night the defense reached out to Ms. Popple and said, we want you to bring the rounds to court tomorrow. And she got their message, and then they reached out to her again and said, no, never mind. We don't want you to bring the rounds to
Thank you,
court
Ms.
tomorrow.
Morrissey.
I
Thank
have
you,
them.
Ms. Morrissey.
I have them.
I don't, okay, where are they?
They're here. I'll go get her.
All right. Well, actually, I want testimony from Ms. Popple on how she retrieved those. So I don't need the box, tell her. I need Popple.
I have tendered the supplemental report to the defense.
Please raise your right hand. Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Have a seat. Talking to the microphone. I would like to read the report. May I see the report?
Yes.
Where is this box of evidence?
In the other room.
I'd like to see it. Do you need to do it, Martine? I need the box of evidence. Have you all inspected this?
No, we have not yet.
Well, how do we want to do it? I want to look at it.
I do too.
Well, do you want me to ask the questions first? I have some questions of this witness.
You can ask first if I want to.
Can I open this, Martine? Anywhere? Like, not in the middle, but I mean up at the top? Oh. Anywhere's fine? Maybe you need gloves too. Do you have gloves? Can you get some additional? So anywhere, I can just cut into it. Okay.
There should be there's a separate
All right.
area.
I'm going to have you. This is unusual, but if you all don't mind, and if there's any objection, I'm going to have her step down, and when I ask her a question about which is which, she will put it out. Is that all right with everybody?
However you want to do it, Judge.
Okay,
Sure.
so I just need you to have some gloves. And we're going to go right there. And you all can approach too, so you don't have to, I don't want you asking questions yet, but I do. Can you move that thing? All right, please pull out the 3 Starline brass 45 Colt. Just put the color. You need to record them? You have your report.
I have my report.
Morning again. I'm just going to pass the witness up, because we're not fully set up, the copy of the spent shell casing that was recovered on the scene of rough. And you would agree with me, right, that it's the same as the bottom of the bullets that you just provided to the court?
Yes, it's Starline brass 45 Colt with a silver primer.
So when I asked you yesterday, didn't he turn in ammunition that matched the ammunition that killed Ms. Hutchins? It's true that he did, correct?
And I did not recall at that time.
I understand that that's your position, but that's what in fact happened. Would you agree?
I would not use the word match without there being an additional analysis.
Well, who got to decide whether there would be additional analysis?
That was not myself.
It wasn't the defense, though, right? We didn't know about it.
I don't know what you were aware of.
Okay. Well, you know that we came to have an evidence viewing where we asked to see every single round that could be related to the Rust set, and this was hidden from us. You do know that.
This was not hidden.
This was not hidden?
This was under a case number. It was documented. I was instructed to document it under this case number.
Okay, so in this case that's under the Rust investigation case number, you would agree with me there's hundreds of things that you inventoried, right?
Yes.
There are hundreds of police reports that all relate to the same case number, right?
Yes.
The one thing that seems to have been put under a different case number is just this one discovery of the actual ammunition that matches the ammunition from the set of Rust.
This was put under a doc information of someone coming in claiming to have rounds that were not utilized in a case.
Okay, well, let's examine that for a second. When Seth Kenny comes into the precinct and he gives you ammunition, you vouchered it, right?
I was instructed to collect the ammunition from Seth Kenny.
Well, let me take a step back for a second just to make something clear. Investigator Popple, you're following orders, right, when you're doing these things, correct?
Can you please stop referring to me as investigator because it's creating a misnomer?
Okay, well, how would you? I apologize.
I'm a
not doing
crime
that.
scene technician. I'm not an investigator.
Okay, I'm only doing that because it's shorter than crime scene technician.
CST works.
Okay, and obviously, and I know it's obvious, but I want to make sure it's in the record, we were not ever shown that, correct?
Well, I believe that you guys had a secondary evidentiary meeting with the sheriff's office that was canceled the day before the meeting was supposed to happen. Or an evidence showing, I'm sorry.
Okay, yeah, we were able to come for some showings and not others. The reality is when we came for showings, you never showed us this evidence, correct?
I don't know if I can agree with you there, because even on the first day that I was present at the evidence hearing, we didn't get through all the evidence that they wanted to see that day.
I don't have any more questions for this witness.
Let me ask you something. If Ms. Popple said it was not in the evidence viewing, would you disagree with her?
If this ammunition, sorry, I just want to make sure I'm understanding.
If what Troy Teskey dropped off was not in the evidence viewing because I can get the testimony, but they had a narrow. If Ms. Popple said it was not part of the evidence viewing, that you did not gather it for the evidence viewing, would you disagree with her?
I believe that we were sent a list of what they wanted to see, and then, Your Honor, the first day that we had done an evidence showing, we didn't get through everything.
That's not what I asked you.
Yeah, I understand, but I'm trying to. Then we had another day.
Pardon me?
We had a second day that was set up to continue.
I asked you if you would disagree that Ms. Popple said that it was not included in the evidence viewing. Not whether you got to it or whatever, but whether when they said we want evidence viewing, Ms. Popple said it was not part of the evidence viewing.
I don't know if it was or wasn't.
Would you disagree with her is what I'm asking.
I really don't know how to answer that.
Thank you. Redirect?
I can't provide the video until she logs into this system. Mr.
You know,
Spivers,
I don't even think the video is relevant. She did not view it until today, so you can look at it. But do you have any cross-exam for her?
I just need to develop my records, so I need to get the video in. I need to get the video in.
You can get the video in, okay? Are you going to get it in through her? Because I said it should come in from the person that wore the body camera.
I agree with you. He's here.
Okay, well, fine. So, do you have any cross-examination for her?
I do. Corporal, as you sit here today, do you have any reason to believe that the ammunition that was provided by Mr. Teskey came from the set of Rust?
No.
May I ask a question?
Sure.
When you say that there were discussions and the decision was made by all of you to put that ammo in a separate file, right? Is that correct? You said that?
Yes, ma'am.
Was Ms. Morrissey part of that discussion?
Yes.
Thank you.
Let me give the court an offer of proof, and if Mr. Spiro wants me to, I'll testify under oath.
You are going to testify.
Sure, absolutely, I'm happy to. I'm showing you State's Exhibit 16. How do you know that's related to the set of Rust?
Because it was collected during a search.
Did it come from the scene?
Yes, I believe that one did come from the church.
State's Exhibit 29. How do you know that's related to the set of Rust?
That was the casing that Marissa collected.
State's Exhibit 10. How do you know that's related to the set of Rust?
Collected.
All of these photographs and all of the items that are in evidence, how do you know they're related to the set of Rust?
Because we got them from Rust, or during the investigation or some part of the investigation.
How do you know these rounds were in any way related to the set of Rust?
I don't.
Okay. Let's bring in Randall, if that's his.
Are you finished?
Yes, I'm sorry. I apologize.
Witness is excused. Thank
Okay.
you. Your next witness?
Basic judge and raise your right hand.
Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Have a seat, talking to the microphone.
State your name, sir.
It's Lieutenant Brian Brandel
How are you currently employed?
at the Santa Fe County Sheriff's Office.
And do you know why you're here to testify today?
Yes.
Were you present when a gentleman by the name of Troy Teskey brought ammunition into the sheriff's department?
Yes, I was.
And at the time, were you running your body-worn camera?
Yes, I did.
And has that now been provided to me?
Yes.
Now, just so that we're clear, when you ran your body-worn camera, how did you preserve that video?
It is uploaded into a WatchGuard cloud.
And when you upload them to a WatchGuard cloud, do you link them to a case number?
Yes, they can be linked to a case number.
Was this video linked to a case number?
I don't recall. I'd have to look at the video, but I believe so.
Okay, and we have the video. I'm trying to... It's transferring over there? Okay, great. Have you watched the video today?
Yes.
Did you watch it with me?
No, I did not.
I have no idea where it is now, so.
Well, we're going to have to mark it before we publish it.
Do you want me to put it on a flash drive for the court and
No,
mark
I
it
want you
that
to
way?
move it into evidence.
Sure. I'm working on pulling it up.
Yeah, sure.
Do you know the date that this was recorded?
I believe it was March 6th, 2024.
Would this be State's Exhibit 2?
I don't know.
I think it is. I'm going to show you what I'm going to mark as State's Exhibit 2. Can we display it?
Yeah, yeah. Well, you're publishing it, and well, go ahead. I mean, it doesn't
I'm
matter.
not sure what.
All right.
Do you
fine.
want to see the video or no?